You're recognized.
Thank you, Mr. Chairman. Mr. Chairman, I'd start with a quick question to Council. Council, excuse me.
Yes,
sir. You know,
Did you want to bring your amendment up?
Oh, yeah, sure. I have an amendment of the desk, Mr. Chairman. Ask it be considered as read.
Clerk will read.
Amendment to H.R. 7.
Without objection, you proceed.
Okay, it's simple. It strikes this whole section. But first I want to ask Council, since the rules of the House require that we file a statement with any bill introduced that says that it has a constitutional justification, have you had someone look at Section 3003 and confirm that it's constitutionally supportable?
Well, the question is, when we submit these, is that do we have the ability under the Constitution and authority?
Right. It's required by the rules of the House. Yeah.
Right.
I get that, Mr. Chairman. My time's ticking away.
But again, I just want to tell you, we
okay, if we could stop the clock since the
parliamentarian. Well, no, we can't do that. Did you want to have further comment from
okay,
council? I'm just
never mind.
Chairman.
Let's just drop it. Let's just
trying to be helpful.
Okay. I've got to say that this is extraordinary. Now, I know there's an assumption that Obama won't be president, but let's think. Giving this authority to any president, Democrat or Republican, it's quite simply distilled. This says a president can determine that a project will enhance the economic competitiveness of the United States. Now, this is extraordinary, and everyone I explain this says, whoa, I can't believe that. That project would then be exempt from all laws of the United States of America. That includes competitive bidding. It includes occupational safety and health. That includes Buy America. That includes, obviously, the environmental laws, which are the target of this section. But all laws, and there would be no judicial review. Now, that's pretty extraordinary authority, and we had a pretty vigorous hearing a few weeks ago here on high-speed rail, which is being promoted by the President. Let's just say Obama gets reelected. Well, by God, we can have high-speed rail anywhere in America exempt from any review by Congress, exempt from any laws and any procedures. The President could just deem it to be for our competitiveness. Now, if it was, let's say, Newt, it would be maybe, I don't know, space station. And I don't know what Romney would do with it. Ron Paul probably wouldn't use it because he's a pretty strict constructionist. But this is unbelievable. I can't believe that this was the intention, and I don't know where this, I'm all for talking about streamlining and expanding categorical exemptions and all that, but to say the President can just deem something as enhancing the economic competitiveness of the United States, and that project, whatever it is, would be exempt from all laws and judicial review. Think about the takings implications here. Wow. This is pretty extraordinary. I can't believe it's constitutional. It probably isn't. A couple of lawyers I talked to said that, but apparently it's been reviewed by counsel and deemed to be constitutional. Beyond that, beyond the President having that authority, any local jurisdiction can submit a project to the Secretary of Transportation, who must transfer it to the President, who must decide within 30 days whether or not that project should be exempted from all laws of the United States of America and judicial review. Any local jurisdiction. And further, if you read, and I don't know who drafted this, but if you read it closely, actually, if the President approves the local project or the state project or the multi-state project to be exempt from all laws and all judicial review, that's fine. That's the end of it.
Will the gentleman yield for 1 second?
If the President disapproves it, the President can be sued for having disapproved the project arbitrarily during the 30-day review period. This is, I just can't even, I can't believe it's in the bill, to tell the truth. I just don't think it meets any test of credibility, Mr. Chairman. I would hope that everyone would agree that this needs to be narrowed a little bit, maybe, we could agree to do something about this section. Thank you, Mr. Chairman.
Mr. Long?
Thank you for yielding, or thank you for the time, and I'm speaking opposition to this amendment. It strikes Section 3003 that allows the President over the next 2 years to expedite a permit. I, too, was here when we had the high-speed rail hearings and the testimony, And I remember the folks from California talking about rail projects that have been on hold for years because of this very thing. I have a bill myself that I walked through the House. It was a bipartisan effort. I had 194 Republicans and 1 Democrat on it, so it was a bipartisan effort. And to look at this very kind of a thing, where projects would be let, everybody's happy, the environmentalists are happy, everybody's happy, they hire people, they go out there on these projects, they shut them down, they file lawsuits. This is to expedite the permitting process in the first place, like we were talking about at the high-speed rail hearings that we had here, where I think high speed was deemed to be 67 miles an hour going downhill. But the President, who Mr. DeFazio seems to have a little problem with, because earlier today he was complaining about the fact that he could appoint people, and then he brought up Grover Nordquist, and I didn't understand. It sounded like he was for
Excuse me,
Grover
point of personal
Nordquist.
privilege. I did not mention Grover Norquist, Mr. Chairman. I don't know what he's talking about. He's confusing me with someone else. Or I have no idea what he's talking about, Mr.
I'll get
Chairman.
the tape for you. You said Grover Nordquist. And
What? Oh, Nick, that wasn't me. This is Nick Rahal, West Virginia. Peter DeFazio, Oregon.
I apologize.
Yes,
Okay.
thank you.
I did.
Thank you.
I did.
You they put us down here in the cheap seats on the front row. We can't see you guys.
He's got that kind of
But back to my point. The President traveled around the country last fall pointing out the need to get a bill done to rebuild our infrastructure so that Americans can continue to compete with countries like China and India. That's what the President told us. We're trying to be bipartisan here. He's also remarked that these infrastructure projects are just waiting to get started. H.R. 7 allows the President to expedite these projects if they will enhance our economic competitiveness. So I'm opposing this amendment because it takes away the authority for the President to get these projects going faster so that we can compete like the President has said he wants us to do.
Would the gentleman yield for a second? Just since you mentioned me.
Well, let me get a
Okay.
question answered first. On the
Okay.
schedule, you were talking about earlier, Mr. Chairman, you were talking about 9 o'clock to call us back for votes. Is that a.m. or p.m.?
That's PM tonight. and,
Okay.
As necessary.
I'll yield.
I thank the gentleman. You do realize that this waives all laws, which would mean Buy America would be waived, competitive bidding would be waived. I think I'm not sure you want to go. I mean, you're talking about concerns about environmental laws. If you just want to offer an amendment straight up to waive all environmental laws, it would be narrower. But you're waiving all laws of the United States of America with no judicial review, which means China could come in and say, we've got a great idea, we want to build this project, but we'll need eminent domain. The President could say, great, here you go. China, go build the project. No Buy America, no eminent, there's no takings, nothing except. Anyway, thank the gentleman.
Mr. Chairman. Will the gentleman yield for a second?
Wait a second now. Who has time?
Yeah, I'll
Nobody
yield.
is.
You have time, Mr. Long.
Yeah.
Yes.
Yeah, I'll yield.
I just have a question. I've been going through the language of this, and I'd like Mr. DeFazio, if he has a moment, because I am interested legitimately in his observations, but I'm not sure I understand where he points to the provision in the law with respect to articulating that judicial review to some extent will be abrogated. I don't know where you are pointing to the law to suggest.
To judicial review.
Yeah. No, but you made some other
Page
comment.
311.2, the submission of an application for a permit and any permit issued or approved under this section, including compliance with all federal laws and regulations applicable to such permit, shall not be subject to judicial review. 311 sub 2.
Mr. Chairman.
Okay. Mr. Long, yield back?
Sure.
Okay. Mr. Nadler.
Thank you. You know, Mr. DeFazio gave us some examples of what could happen. Mr. Long says we must expedite these projects, by which I assume he means we must expedite these projects. And certainly, we're all in favor of expediting projects and of cutting red tape and so forth. But what this bill does is make the President a dictator. I mean, it's so incredibly broad. What it says is the President can say something, and the President can deem a project necessary to the economic development of the United States. And without anybody's agreement, by himself, he can say, because I deem this project economically necessary, it is deemed in compliance with all laws. All laws. That means he can seize your land. In the Judiciary Committee, we have a bill to make it difficult to seize land for private development purposes under eminent domain, because that's regarded as tyrannical. The Kelo decision of the Supreme Court. Never mind that. The President can give the Chinese permission, or can give his brother-in-law permission, to seize your land. You can't go to court because there's no judicial review. He doesn't have to bother paying you for it because you can't enforce the Constitution because there's no judicial review. He can put on your land a private casino that he deems necessary for economic development because some major donor perhaps is running it and is going to get a lot of money out of it. And no one can say anything. And the laws about the environment are waived. The laws about eminent domain are waived. The limits on eminent domain are waived. The laws about paying you are waived. The laws about everything. The laws about competitive bidding, Buy America, everything. This makes the President a complete and total dictator on anything, as long as he says this project is economically necessary for the United States. We had a debate on the floor a few weeks ago in which Mr. Landry was very upset, and properly so, that the President was given the power to say that you are an enemy, are a terrorist, in my opinion, and therefore we're going to throw you in jail forever, without any due process or trial or anything. That's tyrannical. It is. Our founding fathers would blanch at it, but they would blanch at this too, for the same reason. We can't simply say to the President, I don't care who the President is, Barack Obama, of whom I approve, or Newt Gingrich, of whom I may not approve. Doesn't matter. You can't give to any President the authority by his own diktat, with nobody else's say-so, not Congress, not anybody, to do essentially anything he wants, anything, so long as he says it's economic development, and nothing matters. There's no limit to his power, and even if you think he went beyond the power granted by the bill, you can't go to court because it says no judicial review. It's probably unconstitutional, but it ought to be certainly to anybody who says they believe in constitutional limits in the Constitution and limits on the power of government. This ought to be obnoxious beyond belief. This makes the President personally a total dictator on anything. He can do anything he wants as long as he says it's economic development. He can seize your house and build a rodeo or an amusement park, and as long as he says it's necessary for economic development, you can't sue him. He doesn't have to pay you. There's no judicial review, nothing, no remedy. That's not what we want to do. If we want to have in this bill provisions for expediting economically necessary projects, fine. Let's have some reasonable expediting provisions, but not a total, unlimited, unfettered grant of power to King George III, which is what this is the equivalent of. I can't believe that I'm seeing this in a bill that is being seriously considered. I yield to the gentleman.
Well, it doesn't apply to state regulations. It only applies to federal law, including applicable regulations. So,
like the Fifth Amendment, for example, that says no taking without due process of law?
Maybe I should wait and get 5 minutes, because longer than that. Everything you said I would agree with if it applied to state agencies, but it talks about state agencies applying for federal override and regulations, and it says that a transportation infrastructure project with respect to which a permit is issued under subsection A shall be deemed in compliance with all applicable federal law, including applicable regulations. It does not say state law. He has no right to override state regulations, state requirements. I read it, and I'd be happy to discuss it between final. If a state comes in and says we have a disaster, we need to replace a bridge, can you
reclaiming my time? There may be some limit with respect to that, but it still establishes the President as a total dictator. And you have many federal laws which all of us have supported, or maybe some of us have supported, to put limits on the discretion of Federal officials as to what they can do in order to protect people. So that, for example, in the Judiciary Committee, we are considering, I frankly didn't support it, but the Republicans all did, and it passed. A lot of Democrats supported it too. Limitations on the use of eminent domain. This would go by the board. I think that even if the project were a project the State said, we think this is economically important, and the President said, I think it's economically important, you still don't want to eliminate all Federal laws. Maybe you want to say that's a list of Federal laws that you think are less important. But do you have in mind every single Federal law, every single limitation, every single protection of liberty that you are confident that without going through them, it just should go by the board and without judicial review?
I thank the gentleman. I have tried to give time here. We're a minute over now. Who's
Next.
want to make sure I go in the right order. Mr.
Miller.
Miller?
Yes.
Okay.
Based on the way you made your argument, I was leaning to agree with you, and I think further debate needs to occur on this between now and the floor. And it brings to mind an amendment that's going to be offered shortly that by Mr. Bishop that strikes language I put in the 2005 Safety Lieu bill that allows states who meet NEPA requirements or exceed NEPA requirements to just go through one environmental process through the permitting. And the only state in that pilot program that accepted that was the state of California. And it's proved to be very effective. As you know, California has some of the most stringent environmental laws in the country. We have a Democrat governor, Democrat legislature. I mean, they're very environmentally conscious, but it's worked very well. Now, as I read this, and perhaps the language might need to be tightened up, Mr. Chairman, that if a state who doesn't have that authority or guidelines, like many states don't meet that standard, if they have a disaster in their state and they need to fast track an approval instead of having to go through the Federal government for NEPA and other waivers.
Would the gentleman yield?
Just a second, I would be happy to. Other Federal guidelines, and that they could go and get the President, which is the top guy, to override that. That would be applicable, but I share some of your concerns. So don't get me wrong, I don't. What your argument was based on got my attention, and I was very concerned until I looked and it said Federal. So I think perhaps this does need to be tightened up, but I think I understand the intent of what it was to do. But I'd be happy to yield, Mr. Nadler.
Thank you. First of all, this is not simply, as I thought you were saying a moment ago, for projects submitted by the State. If you read it, it starts off by saying, in general, this is Section 3003A, in general, notwithstanding any other provision of law, the President may issue, during the 2-year period beginning on the date of the enactment of this Act, an expedited permit for any transportation infrastructure project determined by the President to enhance the economic competitiveness of the United States. Then you go down 2 paragraphs, and it says a state may also apply to get on this list of projects, but the President can do it on his own. And then it says any such project shall be deemed as in compliance with all applicable Federal laws.
I reclaim my time, Mr. Nadler. I agree. I think we need to tighten this up. But and that argument, I think, is valid. But I think the intent was to deal with public transportation agencies, local government, et cetera, on a project that was critical. So I think it does need to be tightened up. I believe I understand it being applicable to Federal law, not overriding State or local law, but I deemed it to be something in assistance with a local agency. I'd be happy to yield.
Well, it is applicable Federal law, although once you say there's no judicial review, how do you enforce the State law?
No, it does not override State law. It says
no, it doesn't have to override State law. What I said is, how do you enforce it if there's no judicial review?
I reclaim my time. As it applies to Federal law, if it's made applicable to that only, I would understand it, but it's not. It needs to be redone. So there's a
would you yield last time?
Sure.
Thank you. I would suggest, I think most people on this committee would be amenable to reasonable expediting legislation. We're all in favor of that. I would suggest that this amendment ought to be passed. This ought to be taken out, and between now and the floor, figure out reasonable language for that. But this is so dangerous at this point.
Would the gentleman yield for just a second?
I just yielded to the Chairman for a second.
Okay. All right. But John's got his own time. Could I just make one point? I agree 100% with the gentleman on having SEPA reciprocity, and I've supported that. And, to duplicate these processes is unnecessary as long as states have equivalent laws. But this, just when you waive all Federal laws, which would include Buy American competitive bidding, that's pretty radical stuff.
There would
and,
come a
you
time,
know,
Mr. DeFazio, I would have to agree with
Yeah,
you in
okay,
that
thank
case.
you. Thank you.
I said I think I
Yeah.
like the intent, but the way it's written, I think
Right.
it needs work.
Other members
I-
seek
I-
recognition? Mr.
Be happy.
Well, okay, you want to take
Be
some of
happy
his
to yield,
time? Go
sure.
ahead, he's got time.
Thank you. Just for the purposes of clarity, the section to which you referred with respect to making permanent state pilot projects, which you put in place in California, that's Section 3015. I'm going to have a hard enough time with my amendments. I'm not touching 3015.
Nope, I know that. I didn't mean that. I yield back to
But
Nelson. Yeah.
if I may,
Sure.
I
got 27
let's
seconds.
just think about this. Waiving all provisions of law, this would allow the President to approve a project that is constructed entirely by undocumented immigrants.
I reclaim my time. As I stated to Mr. DeFazio, this needs clarification, without a doubt, and I would agree with your concerns. And I think I understand the intent, but the language does not detail that, so I yield back the balance of my time.
Okay, let me see. Did Mr. Miller? Anyone on this side? Okay, Mr. Schuster was waiting.
Thank you, Mr. Chairman. I have great concern about what this language says, and if I get staff to walk us through what's here. You explain it to us from your perspective, staff.
The entire amendment, sir? Are the base language in the bill?
Yes.
It allows the President to issue over a 2-year period, beginning after the date of enactment of the bill, expedited permit waivers, and it does allow for a state, local government, public transit agency to apply for these waivers. Our interpretation and intent is for the waivers that we've been speaking about to apply to the laws applicable to the permit, not to all federal laws, and state law would still apply. So in California's case, CEQA would still apply, and the judicial review would not apply to that.
Again, I share Mr. Miller's concerns. I think it needs tightened up some here because, again, it raises some concerns for me, and with that, I yield back.
Okay. Other members seek recognition. Mr. Meehan was waiting, and then we'll get to Mr. Gibbs.
I do thank you, Mr. Chairman. I do want to agree that there's ambiguity here that I think needs some kind of clarification. And I'm looking for clarification because I was very specifically, as I was analyzing this, and maybe counsel could weigh in and give an impression. The specific question I had as I was looking at it, well, what is this going to do, say, to a Davis-Bacon provision that was included in language in the original contract? Now, I understand, to the best of my skills over the years as an attorney, I'm struggling a little bit to understand the interpretations of some of my colleagues here about where they suggest this is going, because in my experience interpreting statutes, the language prior to this significantly narrows the scope of the ability of the President to act with respect to permits. Notwithstanding, it still is a significant power, particularly where there is no judicial review. In fact, I'm not sure that there's any place where you really cannot have judicial review in a nation like this. But in any event, my specific question is, does counsel have an opinion as to whether this might abrogate any relationship with respect to, say, a Davis-Bacon provision that would have already been written into the contract?
No, sir. We do not think that it would impact Davis-Bacon provisions.
Other members seek recognition or question? Okay, Mr. Gibbs and then Mr. Bouchon. I'm sorry if there was any.
I had a question because during the discussion, they talked about eminent domain and the ability to have casinos or whatever. When I read through the language here, it's restricted to transportation infrastructure. And my experience when we went through the Kelo back in the Ohio legislature, Ohio has a provision that's called quick take, and if it's a transportation, if it's to build a road or whatever, they can come in and use eminent domain, and then they fall through later to depend on the compensation. if it's for public use, there's really no discussion about eminent domain. If it's a transportation issue, it's all about compensation. And so is it you know, a question to ask, the way this is 303, this section's drafted, it's referring to transportation infrastructure. Is that all in that narrow category and not this broad range that the other side was talking about so much?
Yes, we interpret this language only to apply to transportation projects.
Other members seek recognition.
Mr. Chairman.
Mr. Bouchon.
Yeah, Mr. Chairman, I also have concerns. I would like to, the same ones Mr. Meehan and Mr. Schuster, as well as Mr. Nadler have relating to this, and I do think it would be prudent for us to clarify the language in the bill as it relates to, especially lack of judicial review, which is what Mr. Meehan pointed out. I yield back. I yield to Mr. Meehan.
I question whether, in fact, thank you for yielding for a second, whether, and I'm not familiar enough with this area, but the constitutionality may be able to, whether there would be expedited review and the courts would be given a limited amount of opportunity to be heard and a time frame and things of that nature so that there would be some defined review. I don't know how you are able to suggest that there's no review. Maybe there are provisions in the law that say that.
I reclaim my time and yield to Mr. Lankford.
Thank you for yielding on this. Mr. Chairman, is there a way, and I understand the ambiguity here, and I'll look at it as well, and I also see that this is clearly surface transportation, so when you mention things about casinos and that kind of stuff, that doesn't apply in this because it is surface transportation related, but it could also be a road to a casino, and so I get that as well. So it's probably not building a casino, but probably is building the road to it. Is there a way to be able to table this so that we don't have, so we have a second option, one option being right now to clear the whole thing, and another option is to keep the whole thing? Is there a way to be able to table it and say, let's clean it up and then bring it back into another bill? Is there another third option?
Well, with the permission of the sponsor, I guess we could, if he'd be willing to withdraw it, and maybe, we obviously have some very, strong opinions and also positions on this. I see what he's trying to achieve and would be willing to work with him, and maybe some of the others who are trying to craft this, but we really shouldn't be crafting it as we go along.
Well, could I suggest, Mr. Chairman, and I do, could I have some time?
Yes.
On that. On the question the gentleman raised, I actually had a very early experience working with Senator Hatfield from Oregon on what's called sufficiency language, which did exempt projects, federal projects, from any review by the courts. It is possible to do that. So, and this pretty definitively says shall not be subject to judicial review. Whether that be limited just to federal courts or state courts, I don't know. So that is a tremendous concern. I think, Mr. Chairman, the preferable thing to do really would be for this provision to be stricken as is, and then you could rewrite it and put it in the manager's amendment when you go to the floor after some consultation, and because there are concerns on both sides of the aisle about some narrowing here. But that would be.
Well, what I'd prefer to do is to ask you to withdraw it and work, and we will put a provision in working with all the parties that are here in the manager's amendment. You have my commitment to do that. How's that?
Well, I understand that, Mr. Chairman, but I'm not sure what the process would be, whether it would, there are things that you could fix, and I would still disagree with this power to the President. So I'm reluctant to do that, although I appreciate the generous offer. So at this point, I would have to still stand by the amendment. I just think this is a very serious area of law.
Yes,
Mr. Chairman.
Johnson?
Mr. Chairman, could I be recognized?
Oh, yes, Ms. Johnson, yes.
Okay. I'd like to yield my time to Mr. Nadler.
Thank you. I just want to make a couple of brief points. Number one, although it's limited to federal laws that are deemed that are waived in effect, since there's no judicial review, you can't enforce a state law either. You can't go to court and say the President is violating the state law because there's no state law, which means the state laws are gone also. Secondly, although it is limited by its terms to transportation forget the transportation infrastructure projects. If the President calls something a transportation infrastructure project, which isn't, but in his opinion it is, whether that be a casino or anything, without judicial review, you can't question that. So a transportation infrastructure project is anything the President says it is, and all Federal laws are waived, and you can't question his decision because there's no judicial review, and you can't even rely on State laws because the only way to rely on a State law is by to enforce a State law is to get an injunction, and you can't do that by the judicial review, which apparently I would read this as saying judicial review means State as well as Federal review, but it's ambiguous. I would very much suggest this is a very dangerous power. There are ways of expediting. This possibly can be rewritten, but the only safe thing to do is to withdraw the section, pass the amendment, and then see if you can work out something that can get some sort of consensus that makes sense before you go to the floor. I yield back. I'll yield to the gentleman from Tennessee.
Just one point, and I don't have that problem with casinos. Maybe some other people do, to be honest. But the fact is it could affect casinos because you could have a parking lot, which we had in Memphis, built for our sports arena with Federal funds. And allegedly, they said it was going to be a bus terminal and a parking lot, and the buses were going to come in and use the spaces for people to park, get off, use the bus. They never did it, and that's a whole other issue. But the bottom line is they can use Federal funds and did to create a parking as a multimodal transportation for a arena, and they could do the same thing for a casino if they wanted to.
Mr.
Go back to
Denham.
Mr.
Reclaiming my time, I'll simply say that I don't necessarily have a problem with casinos anyway. I was just trying to think of something that clearly isn't the transportation project. That's what came to mind. I yield back.
Mr. Denham, briefly. And then I have a comment.
Well, Mr. Chairman, I think that Mr. DeFazio understands the amendment and this language very, very well. It waives NEPA. Something I'd like to see done, especially when it comes to high-speed rail. If this President would like to get high-speed rail done, then he could lower the cost, expedite the program, so it's not going to take an additional 10 years, and we might cut a couple $1 billion off. Now, he's still going to have to come up with about $80 billion, but at least it would cut a couple of billion off. But this is done all the time, done mostly in Democrat districts. You know, whether it's the Pac Bell Park or the new arena in L.A., both of them are done in Democrat districts because Democrats wanted to waive it for their projects. But this is just dealing with transportation, specifically 3003. You know, we have done it for the earthquake in L.A., did it for the bridge in San Francisco, for transportation projects in an emergency. That's what dealing with Section 3004 for an emergency. 3003 gives him the power to exempt NEPA in these other circumstances. So yes, CEQA, which is much bigger, much grander than NEPA, would still exist. You still have to go through State law. It's very clear here. Very clear that it's just transportation projects. You can call it what you want, but you obviously have read the bill, which amazes me because earlier you said you hadn't read the bill, you hadn't seen the bill, but you were able to get an amendment in 3 days ago. So I think it's very clear. I support this section because it does waive NEPA, it will save money, it will expedite projects, and if it's really about jobs, we ought to give this President an opportunity to create some jobs and get some of these projects moving. I yield back.
Thank the gentleman. Mr. Rahal.
Mr. Chairman, I yield my time to the gentleman from Oregon.
I thank Chairman. That was very, very interesting diversion from the reality of this amendment. Let's be clear here. I got this amendment in yesterday at 3 o'clock. And no, I have not read the bill in its entirety. I admit to that, as did every other member of this committee, including the Chairman. I have pinpointed sections by scanning the bill, but I haven't read it in its entirety. I'll tell you a story. This guy tried to put one over on me when I was a young member here by changing some provisions of law that related to compensation for Federal lands. Yeah, you're right there.
Not me.
And I only found it because I read the whole bill, and I said to my staff, there's something fishy about this language. I think the words are reversed. And yes, indeed they were. And Nick said, you caught me. You had my hand in the cookie jar. Okay? So, but I haven't had a chance to do that with this bill. So I don't know what else there might be in here. I have found some things that I find particularly problematic. But in terms of, you know, I have had numerous conversations and fully willing to work on the equivalence with SEPA and other things and expanding categorical exclusions where appropriate and all those things. But to give this authority to a president unknown, whoever that president is, to waive all federal laws goes far beyond. If you're just trying to waive the environmental laws, be straight about it and say all environmental laws are waived, but we're not waiving, I don't even know what provisions of law there are that might apply to a transportation project beyond labor law, occupational safety and health laws, Buy America laws, competitive bidding laws. Those all would be gone. Environmental laws. I assume there are many other. I don't even know. And I think it's unwise to say all laws as opposed to saying these laws and then list them.
All right.
And then the judicial review issue. Thank you, Mr.
Here's
Chairman.
what we're going to do then. We're going to go ahead and I'll accept the DeFazio amendment with the caveat that we work on it and we try to resolve some of the differences in language. Without objection here, the vote will occur on the DeFazio amendment, and with, again, the caveat that we work together, and there's some great minds here, and we'll try to get in a manager's amendment that comes to the floor provision that's acceptable. So with that, the vote occurs on the DeFazio amendment. All in favor signify by saying aye. Opposed, nay. The ayes have it. The amendment's agreed to. And we'll go next to Mr. Lipinski. No, we did that. I'm sorry.